Welcome to the Deep Dive. We're here to cut through the noise, get straight to the insights that, well, really matter. Today, we're diving into something affecting countless professionals trying to build a career here in the U.S. It's about those often unseen, but incredibly critical challenges, the ones that career growth and job promotions can suddenly create, especially if you hold an H-1B visa. Our mission today, to really unpack this complex info, help you understand what it actually means for your professional journey.
Yeah, it's become absolutely pivotal, hasn't it, for anyone navigating the U.S. professional world? Understanding the complexities of U.S. immigration rules, specifically around the H-1B, is, well, it's more crucial now than maybe ever before. We're seeing significant policy shifts, heightened scrutiny. It really raises the stakes for visa holders who are looking to advance their careers. What seemed straightforward before is now, kind of fraught with these intricate legal points.
Okay, let's unpack this then, maybe with a scenario that might hit close to home for some listeners. Imagine you're on an H-1B visa, right?
Yeah.
And you've just landed a great promotion, fantastic news, new title, bigger responsibilities, and yeah, nice, well-deserved salary bump. Sounds like pure success. Time to celebrate. Yet we've seen situations where this exact kind of win, this career high five, actually puts a person's legal status in jeopardy. Unexpectedly. It's a strange paradox, isn't it? A career step up, something everyone works for, could risk your ability to stay and work here. How does that even happen?
It really is one of the most counterintuitive parts of the whole H-1B system. The core issue, it boils down to the definition of your authorized employment. See, under H-1B rules, your visa is tied very specifically to the job role you were initially approved for. So any substantial change, and that means a new job title, a significant shift in your day-to-day duties, or even a notable change in pay, might require your employer to file an H-1B amendment.
An amendment with USCIS, right? U.S. Citizenship and Immigration Services.
Exactly, with USCIS. And here's the critical point. If that amendment isn't filed correctly, or maybe worse, not filed at all, the visa holder is suddenly at significant risk. They could lose their authorized status. Their legal right to work, to live in the U.S., could just become invalid.
Wow, so it's definitely not just some administrative checkbox then. It's fundamental to the legal authorization itself.
Precisely. Let's take that specific example we were looking at. The professional promoted from quality engineer to electrical engineer in, say, September 2024. Salary increase included. On the surface, it looks like a clear step forward, no question. But moving from quality engineering, which is often about testing, assurance, standards adherence, to electrical engineering. That involves design, development, maybe circuit analysis. That's a fundamental shift in job duties. Even if they're in the same general field, they're often seen as distinctly different occupational classifications by the government.
Okay, so the duties change significantly.
Yes, and then you add the salary increase. That combination directly impacts something called prevailing wage applicability. Now, prevailing wage, simply put, is the average wage paid to similar workers in that specific job, in that specific location. The Department of Labor sets this, and it's a critical benchmark for H-1Bs. It's meant to ensure foreign workers aren't, undercutting U.S. wages. So if your new role, maybe your new salary, doesn't align anymore with the original visa terms, maybe it falls into a totally different prevailing wage category, or the new salary is less than what's required for the new role.
Ah, okay. That triggers a problem.
It immediately triggers new compliance hurdles. Without an approved amendment that reflects these changes, the worker might simply not be considered properly authorized anymore. Their status effectively becomes invalid from the moment those job duties substantially change if the amendment wasn't filed. And that can lead to really serious consequences. Risk of deportation, huge problems with future visa applications, you name it.
That is quite a realization. So the big aha moment for you listening is probably this. These seemingly great career moves, the promotions, the raises, the exciting new roles you're striving for can come with these hidden, really complex procedural strings attached. And these strings are often completely missed, until it's potentially too late. You could genuinely think you're doing everything right, climbing the ladder, only to find out you stepped onto an immigration minefield. It just highlights how crucial being proactive is.
And what's fascinating here truly is that this kind of individual experience isn't just an isolated case or some bureaucratic oddity. No, it's a direct reflection of much bigger systemic shifts happening in U.S. immigration policy overall. Over the last few years, we've definitely seen a significant push towards, heightened scrutiny around H-1B practices generally. The government's stance seems to be evolving, demanding more rigorous compliance, more transparency. Often this is driven by, political talk about protecting domestic jobs or concerns about potential program misuse.
So it's part of a bigger picture.
Absolutely. And one of the most talked about changes, potentially very impactful, is this proposed rule change. It emphasizes a much stricter wage-based selection system for H-1B visas. This would be a major pivot, really, from the random lottery system that's been the standard for years. What it means, essentially, if it gets implemented, is that future H-1B visas might be allocated more heavily based on the salary offered, higher salary, higher chance of selection.
Instead of just random luck of the draw.
Exactly. It could drastically change who gets picked, the types of roles prioritized. Proponents will argue, look, this ensures we bring in the highest skilled, highest paid workers. But critics worry, it could discourage companies from hiring entry-level talent on H-1Bs. It might hit startups, impact innovation pipelines. It's a big debate.
And here's where it gets really interesting, maybe even more complicated. Beyond just that wage-based idea, there are other regulatory shifts happening too, right? Specifically targeting exemptions.
That's right. Think about universities, nonprofits, government research labs. Historically, they had certain exemptions, allowing them to petition for H-1Bs outside the main annual cap. Now, those exemptions are also under review. They could face new interpretations, maybe even get eliminated entirely. So it just adds another pretty formidable layer of complexity. It contributes to this rapidly changing landscape for, well, everyone involved in the H-1B program. It's not just one small change. It feels more like a systemic recalibration across the whole H-1B ecosystem.
And the effect of all this uncertainty.
Oh, it's profound. The ripple effect is huge. It's creating significant anxiety. You can feel it, not just for individual visa holders, but within entire industries like tech, finance, healthcare sectors that really rely on global talent. We've heard anecdotally and through reports numerous instances of companies, especially big tech firms, actually warning their own employees internally, telling them maybe hold off on international travel right now.
Seriously. Because they fear visa issues on re-entry.
Exactly. Their concern is real. They worry employees might face sudden visa revocations or denials trying to come back into the U.S. because of these shifting policies and the increased scrutiny you see at airports and consulates. And this isn't just theory. We're seeing more RFEs requests for evidence during the visa process itself. Longer interviews, more probing questions at consulates abroad. Companies are having to adjust hiring plans, pour more resources into legal compliance, and sometimes, sadly, maybe even limit promotions or internal moves that could trigger these complicated processes. The stakes feel incredibly high right now, and the environment is, well, undeniably volatile.
So, okay, given all of that context, the big question is, what does this mean for you listening? If you're currently on an H-1B, or maybe you're even thinking about a career path that might involve one down the line, how do you possibly navigate these complex shifting waters? How do you safeguard your professional future in the midst of all this?
Yeah, if we try to connect this back to the bigger picture and make it practical, it really boils down to vigilance and, critically, being proactive. If you have an H-1B visa, you need to understand that the responsibility it often falls on you, working closely with your employer, to actively protect your status. This isn't something where you can just sit back and assume everything's fine. It requires active engagement, constant awareness of your situation.
Okay, so let's get specific. What are the absolutely crucial, actionable steps an H-1B holder should be taking right now, especially if a promotion or job change is on the horizon or just happened?
Number one, without a shadow of a doubt, consult an immigration attorney promptly. This is not the time to delay or guess or assume your HR department has it all covered, even if they're great. Any substantial change, a new title, significantly different tasks, maybe reporting to a new manager in a different department, even a salary change that shifts your wage level, it may require an H-1B amendment.
So an attorney helps figure that out for sure.
Precisely. They can look at your specific facts, your job descriptions, old and new, the salary, everything, and advise you on the necessary steps. It's always, always better to verify with legal counsel before you officially take on that new role. Second, you need to actively verify prevailing wage compliance. This is super critical if your pay changed. You and your employer need to ensure your new compensation meets or exceeds the required prevailing wage for the new role in your specific geographic location. The Department of Labor data is key here.
Got it. Attorney first, then prevailing wage check. What else?
Finally, documentation. Maintain meticulous records, always. If you're ever questioned later, maybe during a visa extension application or when applying for a green card, or even just during an interview at a U.S. consulate, if you travel abroad, you will need clear proof. Proof of any role changes, updated job descriptions, copies of all the filings your employer made related to your H-1B status, approval notices, everything. That paper trail, digital or physical, can be your absolute lifeline. It proves you've maintained valid status the whole time.
That is incredibly valuable, very practical advice. It really hammers home the importance, doesn't it? Taking those proactive steps, ensuring every I is dotted, every T crossed, procedurally. It's vital to avoid those unintended, potentially devastating consequences in this very dynamic environment we're in. It's clear it's not just about being great at your job anymore, it's also about making absolutely sure your legal status can robustly support your career growth. So to quickly summarize what we've dug into today, we've seen the critical importance of really understanding the H-1B visa rules around job changes. It's not intuitive. We've talked about the absolute necessity of timely amendments filed with USCIS when those changes are substantial. And we've placed it all in the broader context of these evolving U.S. immigration policies that really demand heightened vigilance from every international professional here.
And this perhaps leaves us with a significant question for you, the listener, to think about as you navigate your own path. How will this increasing complexity in immigration regulations, these ongoing policy shifts, how will they impact not just your individual career progression, but also the bigger picture? Things like the global mobility of talent, the very nature of international work, innovation. How might all of that change in the coming years? It's a question that definitely extends beyond just individual visas, potentially shaping entire industries and economies around the world.
All the best to you in navigating these complex waters. And we will meet again with another important subject in the next meeting.